Mr. Speaker, sir, thank you for allowing me to participate in this debate. I rise in support of the bill. Sir, this bill is intended to rationalize the workings of the Tote board, which is now responsible for regulating gaming and betting in Singapore, and to address certain gaps in the law that currently exist. As such, I only have 2 points to make. Firstly, Clause 10 of the bill repeals the existing Section 15 of the Act and introduces a new Section 15, which essentially provides that it is lawful for any person of or above the age of 18 years to participate in licensed gaming or betting. This is a relatively low age and is of some concern given the trend of Singaporeans starting to gamble at a young age. A survey released by the government in May this year found that a quarter of respondents started gambling when they were less than 18 years old, up 10% from 2005. Setting the legal age for gambling at 18 years risks exacerbating this problem. I would therefore like to ask the Minister to clarify and explain why and how this age of 18 years was decided upon, especially when this is lower than the age of 21 years, which is required for entry into the upcoming casinos under the Casino Control Act. On a related note, this new Section 15 now makes it explicitly clear that those who are 18 years and above may lawfully gamble with licensed operators, which is something that was previously not so clear. So this is positive. This also means that by implication, those who are below 18 who somehow manage to gamble with licensed operators are committing an offence under the Betting Act or the Common Gaming Houses Act. But neither this Act, nor the Betting Act, nor the Gaming Houses Act impose any liability on licensed operators if they allow those who are below 18 to gamble. That seems to be a lacuna in the law which should be plugged so as to drive home to licensed operators the seriousness of their responsibility not to allow young persons under the age of 18 to gamble. Secondly, sir, Clause 14 of the bill introduces a new Section 20B that empowers the Minister to exempt any person or class of persons from any or all provisions of the Act through Gazette notifications. There is no statement as to the purposes for which such exemptions may be granted. Sir, the debate on the casinos shows that gambling remains a sensitive issue in Singapore, which many Singaporeans are greatly concerned about. This broad power to the Minister to grant exemptions is worrying because it potentially deprives Parliament of the opportunity to review and debate proposed exemptions. If the Minister is of the view that this power to grant exemptions is administratively and operationally desirable and necessary, then I would suggest that at a minimum, the new Section 20B should be amended to explicitly state the purposes for which exemptions may be granted. Sir, with that, I support the bill.